Hey, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to this episode of Winning Isn't Easy. Before we get started, I've got to give you a legal disclaimer. This podcast isn't legal advice. The Florida Bar Association says I have to say that. And now that I've said it, nothing will ever prevent me from giving you an easy to understand overview of the disability insurance world, the games that disability carriers play, and what you need to know to get the disability benefits you deserve. So off we go. Now, one of the primary fundamentals, if you will, of disability insurance litigation is that you, as the policyholder or plan beneficiary, have insured your occupation, not your job. And disability policies or plans have different definitions of the term occupations. And I have found in the course of my practice that the requirements for proving disability can vary depending on a person's occupation. In today's episode, I'm going to explore three different occupations, their corresponding claim denial or terminations. I'm going to talk about how each claim its occupation may or may not have influenced the outcome of their claims and the lessons that you can learn, regardless of what your occupation might be. So, we're going to talk about three things today. First, I'm going to talk about UNUM's termination of a long-term disability benefits for a Johns Hopkins nurse with fibromyalgia claim was upheld by a Florida court and why. Secondly, I'm going to talk about a Blue Cross Blue Shield senior claim recovery specialist UNUM disability claim for visual issues and how that was reinstated by the court. And lastly, I'm going to talk about how First Reliance successfully terminated a lawyer's benefits for chronic fatigue syndrome. So we're going to talk about each occupation, the nature of the disease, why the claim got terminated or denied, and the lessons that can be learned regardless of what occupation you are performing. Got it? Let's take a break.
Have you been robbed of your peace of mind by your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claims process. Request your free copy of the book at caveylaw.com today.
Welcome back to Winning Isn't Easy. Let's talk about UNUM's termination of a long-term disability claim for a Johns Hopkins nurse with fibromyalgia and undifferentiated connective tissue disorder. I have many of these cases, and I know that fibromyalgia and undifferentiated connective tissue disorder is one of the most debilitating medical conditions. In fact, my daughter has fibromyalgia, so we live with this. Disability insurance companies and plans will often demand objective evidence of functional restrictions and limitations assigned by the treating provider, even though the beneficiary, the policyholder or the plan beneficiary, has been getting benefits for years, crazy as that may sound. So let me tell you the story of Ms. Eagleston, who was a former nurse at Johns Hopkins. She suffered from chronic pain due to arthritis, UDCT, and fibromyalgia. And despite getting those benefits for years, her claim was eventually terminated. Let's start out with why. What's in your medical records can make or break your claim. And UNUM regularly had her medical records reviewed through the 8 years that it paid benefits. Now, they consistently concluded that her subjective pain prevented her from performing even a sedentary job. And as we know, nursing is not necessarily a sedentary occupation. But by September of 2021, her condition appeared to be stable. She had relatively normal physical examination findings and normal lab results. Now, as an aside, we know that fibromyalgia will normally present without lab findings, right? That's not the nature of the disease. It's based on physical exam findings, primarily pressure points and trigger points. The other thing that we know is that some unconnective tissue disorders do present with positive lab results, blood work, serological type tests, but not all of them do. So we've laid the foundation, if you will, for the nature of the disabling medical condition. But here's the problem. As part of its annual review, UNUM conducted a social media investigation. And guess what? They uncovered posts that suggest she was involved in a catering business. She had traveled to the Caribbean, to Houston. She had attended a wedding. And this marked the end of her benefits. Now, one of the things that is crucial is that her medical records documented regular flare ups and persistent pain, but there was no change in her medication and treatment. And she wasn't necessarily reporting to her physicians the extent and nature of her physical activities. Her physicians, relying on her, said, hey, look, we think she is and remains disabled. And ultimately, UNUM said, nah, we're not so sure about that. So they enlisted a nurse, a family medicine provider, and an internist to review her medical records, all of whom concluded that she was capable of engaging in at least sedentary work. Ultimately, this case ends up in federal court in the Southern District of Florida. Now, first off, you need to understand it doesn't matter how long you're getting benefits. As a practical matter, you have the burden of proving your rights to benefits. I know that in some circuits, the case law says, well, if you're on claim for a while, the burden sort of shifts to the carrier. As a practical matter, I don't find that to be true. And particularly in the 11th Circuit, we have a standard of review called arbitrary and capricious. Basically means that the carrier has the discretion to make all of the benefit terminations, and it's essentially a golden handcuff on the judge. Now, the court's job, at least in the 11th Circuit, is to determine not if this decision was right or wrong, as crazy as that may sound, but whether or not there was a reasonable basis for the decision based on the information that UNUM had at the time of the claims denial. Now, she had 7 treating physicians who consistently reported that she was unable to return to work because of her self-reported conditions, her pain levels, her physical exam findings, and imaging over many, many years. She also underwent a functional capacity evaluation, which normally is considered to be a gold standard evaluation. But UNUM had 3 medical reviewers who all reached different conclusions. Under ERISA, there's no treating physician rule. That means that the carrier or the plan can interpret medical records differently and assign weight to different medical opinions and assess a person's ability based on the social media post. That's not considered to be arbitrary and capricious. Now, let's take this apart. What the problem here was, I think, is not so much her occupation. Her occupation was a nurse. That does require her ability to sit, stand, move, lift, concentrate. The problem was, in my view, the social media posts that showed that she was engaging in activity that was inconsistent with those kinds of occupational duties or duties of a sedentary nature. The other problematic concern here was, I don't think, at least based on my reading of the case, that the medical evidence really tied in the functional capacity evaluation findings and explained why whatever she may have been doing on social media was not necessarily consistent with work. So, number 1, stay off of social media. Number 2, make sure that you are giving an accurate history of your symptoms and functionality, the nature of flares, the frequency of the flares, how long they lasted, how they impacted the ability to function. Make sure that your doctor is doing a thorough physical exam, documenting all of the objective findings, particularly if we're dealing with fibromyalgia. There needs to be this consistent report of symptoms and functionality. It needs to be tied together with a functional capacity evaluation endorsed by the doctor and rebutting the conclusions of the peer review doctors. And then, of course, what we need to do is have a vocational evaluation report that ties it all together in a nice packet. But when you have a medical condition where your physicians are relying on your subjective complaints, you need to be consistent. You shouldn't be doing stupid things. You shouldn't be on social media. You shouldn't be posting about traveling. You shouldn't be doing things that are inconsistent with the nature of the disease and the complaints that you're complaining of. So stay out of trouble. Don't do those things, please. Got it? Let's take a break.